GDPR was enacted in Germany in May 2017, so they're already under GDPR. Their casework, their caseload could be persuasive precedent before it comes into effect in other countries by May 2018. The German statutory authority finds that Deutsche Telekom has suffered a major data breach during 2017. Deutsche Telekom are fined €20 million as a result of the breach, or 4% of global turnover. We'll come on to that later on when we get into the 80s. The UK Information Commissioner's Office finds that in June 2018, so once we're under GDPR, TalkTalk have suffered an identical major breach. What do you think would be the outcome?
Well, if you're applying consistency, there should be...
Wouldn't be any less than 20 million.
But you're saying it wasn't?
No. What I'm saying is, it would come down to my learned friends, because TalkTalk's lawyers would say, oh, well, that's Germany, we're different. You know, we have different local law. And then you would have a sliding scale, potentially, to say, okay, but in mitigation, you didn't do this. We'll knock something off. In mitigation, you didn't do this. We'll knock something else off. But part of your data breach was this, which didn't occur for Deutsche Telekom, so we're going to fine you an additional amount for that. But it would all be floating around that 20 million. Because if TalkTalk, people talk about, I'm going to dwell on this slightly, because this is where the elephant in the room starts coming out. If you follow GDPR, if you've had an interest in it for a while, and whether you have or whether you haven't, there's this continual toing and froing about the ICO is going to come in and they're going to fine the news agents 20 million for a data breach. Well, they aren't. It's got to be fair and proportionate. What's fair and proportionate to a news agent isn't fair and proportionate to TalkTalk or Vodafone, and vice versa. If you find Vodafone the same as you do, you know, Mrs. Smith in the corner shop news agents, that's not even static on the balance sheet for Vodafone. They wouldn't feel that. That would be like chucking a stone at an aircraft carrier. You know, it's just nothing. Wouldn't make an impact.
But in terms of the consistency, does the breach have to be the same type of breach as well as you've got you're comparing apples with apples?
Yeah, absolutely.
You're two telecoms companies, and it's if you've got a rather similar breach and anything else there, it'd be quite easy to apply a consistency approach. But it's when you get different types of breaches and different types of companies involved.
Well, the breach, we'll get onto this when we get into the 80s on these articles, because that's where it starts to define where the two levels of fine come in. Because there's 20 million 4%, 10 million 2%. The 20 million and the 4% is where you've pretty much decided that you don't want to obey the regulation. You know, I haven't got your consent to use your data, bollocks, I'm using it. There's your breach. That's a major breach. I want to send data to your country, you're not adequate, up yours GDPR, I'm doing it anyway, 20 million. Right? That's that parameter. I haven't properly trained the DPO. That's an administrative breach. It hasn't materially affected the rights of a data subject, but it has hampered my ability to deliver the protections to the data subject. So, when you're talking about the rights of the data subject and the protective mechanisms in place, so you're talking about and the legal basis. So you've got legal basis for processing. If you breach that, you've got the rights that, you know, I haven't erased your data on request and I have no basis, no legal basis not to. Or I've sent your data to a non-adequate company without the mechanisms in place, 20 million. I'm not saying you'll get fined 20 million, you're in that frame of fining. But if you've got administrative things, like you haven't recorded stuff properly, you know, you've run a data protection impact assessment and you haven't recorded it properly somewhere, that's the 10 million. It hasn't materially affected the rights of the data subject, but it's undermined your ability to protect the data subject. There's a potential causal link there, but there's no direct link. Because you could run for 10 years without doing a proper data protection impact assessment, and nobody would suffer. And then you could potentially have an issue where there's a data breach.